today we're talking about some scary stories. We got into the Halloween theme, I think, this month at Generations Law Group, and we decided to talk about some of the scary stories that happened when people don't plan ahead. And attorney Phil Summers and attorney Cathleen Summers are going to be talking with us and sharing some stories and how we can make them not so scary for ourselves.
Well, welcome everybody, and thank you so much for joining us today. We're going to do things a little bit differently. Normally we do an actual presentation, but today Phil and I are just going to kind of talk with you guys about the things that we have seen in our practice in terms of issues regarding probate. And when we talk about probate, just a little background, we're not only talking about wills and maybe some disaster stories, horror stories regarding wills, but also things like guardianship and conservatorship, as they also fall under the whole probate process and probate proceedings. So I thought I'd start out today and just share a little bit of some familiar celebrity stories, because these are actually really interesting. You would think people who, have large amounts of estates or large business interests, that kind of thing, would be more sophisticated with respect to estate planning. But as we can see, many people don't really understand and don't plan for what happens after their passing. And there really can be some very unintended consequences. So let me begin by just kind of talking about some different stories that we found regarding some celebrities, some well-known people in terms of how their estates were handled. So I want to start with Gene Roddenberry. Any of you who are Star Trek fans, Gene Roddenberry was the creator and producer of the Star Trek series. And his isn't really a horror story, but more of one of the things that an estate plan can achieve. And for him, he had asked his family in his estate planning documents to ensure that his ashes, a part of his ashes, were sent into space. And so, interesting enough, Gene Roddenberry died in 1991. And at that point, there wasn't an ability to be able to fulfill his wishes for his ashes to be sent to space. But in 1997, his family was ultimately able to get some of his ashes on a satellite that was headed up to space. So I thought that was kind of interesting, the kinds of things that people try to plan in their estate plan. There's another one, a gentleman who, Fred Barr, who actually was the creator of the Pringles potato chip. And one of the things he put in his estate plan is he had requested that his family cremate him and that they put his ashes in a Pringles container. And his family did honor those wishes. So it's some interesting things about people, things that people may think about in terms of their estate plans. But let me kind of switch gears and talk about some horror stories or some unintended consequences for when estate plans aren't thoroughly thought through. So the comedian Robin Williams, who passed away several years ago, interesting with Robin Williams, he actually did have a fairly robust estate plan. And in his estate plan, he had been married previously. He had 3 children, and his second wife, who was his wife at the time of his death, in his estate plan, he had left the bulk of his estate to his 3 children, but he left the house to his wife. And the unintended consequences here, even though all of that was very clean, first of all, he had done this through a will, and we'll talk a little bit about the differences between planning with a will and planning with a trust. But because it was in a will, there was an entree into the probate proceeding, into the courts. And one of the things that hadn't been addressed in his will was his personal effects that were in the house, furniture, art collection, this type of thing. And that ended up being a protracted argument between his children and his wife over what should happen with those personal effects. Ended up costing the estate a tremendous amount of money and really did ruin the relationship between his wife and his children as they thought about what was going to happen to his personal effects. So making sure that the estate plan really does address, particularly if you have personal effects of any value, does really talk about how you want all of that to be divided. Some people may know the singer Prince, the musician Prince. He died a few years ago. And interesting enough, when Prince passed away, he did not have any estate plan in place. So he had no will that outlined what his wishes would be after his passing and how his estate should be passed on. He was never married, never had children. And what ended up happening is his estate, because it was what we call intestate, meaning no will providing instructions, his estate was now or is now being divided among his heirs. Well, you can imagine how many people have come out of the woodwork to claim that they have some family relationship with Prince and that they should be considered in this pool of heirs who are going to be taking under his estate. And because of the complexity of his estate, things like ownership of companies and his music rights, all of that kind of thing, you can bet his estate is going to end up in litigation for many, many years before any beneficiaries end up seeing substantial benefit from the estate. So again, a situation in which, because he didn't plan, people who he may not have intended to benefit from his estate are going to benefit from it, his siblings in this case. And it's really led to an incredible amount of litigation around who is going to be a beneficiary under the estate and costing the estate a tremendous amount of money. So those are just some very brief discussions of some famous people that we all know who have had issues with the fact that their estate plan either didn't exist, that they never provided any kind of direction, or the estate plan wasn't thorough enough to be able to really cover all of the different potential situations that may arise. So now we want to talk a little bit about where some of the things that we've seen, both in our practice and in dealing with colleagues of ours, and horror stories that we have heard in the probate courts of some unintended consequences to not having a good estate plan in place. So Phil, I didn't know if you wanted to start off and talk
Sure.
about wills.
Sure, I'd be happy to. Welcome everyone again. Thank you for joining us. So, we're going from like the more, again, sensationalist stories to what we've seen in our practice, and these are the ones you don't want to hear about, or you want to be the person that it happens to. So we get a lot of clients who come in that they create a will someplace else, maybe on LegalZoom or something else, and there's oftentimes so many problems. Like, for example, they weren't properly executed. In Massachusetts, you have to have two what's called disinterested witnesses and also a notary. Disinterested means you're not named in the will. I can't tell you how many times you've seen wills that had a son or daughter act as a witness, which makes the will invalid. We've also had another client who came in and their daughter notarized the will. Again, makes the will invalid or subject to be contested in a probate court. Also, I had a case where a client, it was a grandfather. He had a beautiful piano. Maybe it was a Steinway or something like that. It's probably, I think, my understanding is probably worth $30,000 or $40,000. Very, very nice piano. He used to give piano lessons to his granddaughter. They had a nice relationship. They played quite a bit on the piano together. It was really kind of a nice legacy he wanted to give to the granddaughter. So in the will that he created himself, he wrote down, he should have put it in the will. He bequests this piano and piano bench to his granddaughter. Unfortunately, he put piano bench. He forgot to put the word "and" between it. So unfortunately, the family had a dispute, and the granddaughter only got the piano bench and not the piano. So unfortunately, the probate courts can be very exacting. They look at the four corners of the document. And while we could think that's an error, unfortunately, the probate court did not view it that way. Another issue, we've seen that, in order to kind of placate family members, we have co-PRs, or in one of the cases I had, they named 3 co-PRs to manage the probate. That is something that obviously went against legal advice. Not something we would ever recommend. Having 2 co-PRs, first of all, they have to agree on any actions. Banks don't like that at all, because you have 2 people. Was one revoked? it causes a whole host of problems. And if you add a third, it just compounds or exponentially makes the problem worse. Because anytime you're dealing with assets, all have to, excuse me, agree. If they don't, then nothing happens. And unfortunately, we're back and forth to the court to get the judge to kind of rule on some of these disputes. One of the other, I guess, misconceptions out there is that I don't need a will. If I die, it's going to go to my surviving spouse, and that's may or may not be true. It only goes to your surviving spouse. Again, it's called you're dying intestate without a will. If your surviving spouse, if this decedent had no parents that are alive that predeceased the person, or any children, for example, from a prior marriage. We had a case quite a few years ago where a son, he died quite early on in his marriage, left a widow. His father had abandoned the family early on. He had absolutely no relationship with the father. Unfortunately, due to the intestate laws, the decedent did not have a will. The wife got the first $200,000 and 75% remaining of the estate. That's the way the intestate law works. The father got a substantial inheritance, quite frankly, very unintended, and he took that inheritance. He was legally entitled to it, and he took it. Not a scenario I can imagine the decedent or the widow could have possibly imagined. But this is the issue when certainly you want to talk to an estate planner to think through your estate to make sure everything is going to pass according to your wishes. We should talk a little bit about probate. Probate is a very public process. You have to file your will with the probate court. Anyone could go into the probate court and look at the will or look what's in the estate. Nosy neighbors, creditors of your children, ex-spouses of your children, anyone can take a look at it. The other thing about probate in Massachusetts is unfortunately very slow. It takes several months just to get someone named as the personal representative of the estate, or executrix. We call it personal representative now. So just think of that. If there's any assets that are in the decedent's name, it could be months before loved ones would have access to those assets. And in Massachusetts, you have to keep an estate open for 1 full year, and that's to allow creditors to file any claims. So probate can be a very time-consuming, slow process, and a very public process. So we often try to avoid that. How do we avoid probate? Well, first of all, jointly held accounts. So look at probate in one context, that you're trying to take assets that are solely in the decedent's name and then retitle them to who are the intended beneficiaries, or the persons who are named in the will. So if the bank account is only in the decedent's name, then you'd have to go through probate. If it's jointly held, then you avoid probate. By operational law, that bank account goes to the co-owner. If you have a transfer on death or a named beneficiary, that also avoids probate. And also trust, if you have it in trust. So I think Kathy's going to talk about that in a little bit. Or actually, I think right now, I think you're going to talk about estate plans. Is that right, Kathy?
No, I'm going to jump in with a couple of other horror stories, if we could, Phil, of some things that we've seen. Phil had talked about, wills that we oftentimes see that people have either done a long time ago. So one of the things that we often see are people who have not touched their will or their estate plans if they had done one for many, many years. We had a client situation that we had dealt with. The decedent, the person who died, had originally done their will in the 1960s. This person had never married, never had children. And all of the people who they named in their will were people like their aunts, uncles, their parents had been named. And none of these people ended up being married and having children of their own. And the other thing the will didn't do is it didn't tell us what to do if someone who was supposed supposed to get a benefit under the will was no longer alive. We call that person usually a devisee. And so if a devisee had predeceased the person, there were no instructions in the will as to what should happen to their share. So fast forward, the person died back in the mid 2010s and had never updated their will. And what ended up happening was that even though a will was in place, because all of these assets, we didn't know what to do with them, we didn't have identified beneficiaries, it ended up being treated very much like an intestate situation, almost as if no will did be involved. And we had to go about finding out who the next of kin was. Come to find out, there had been a half brother who had also predeceased, but had children that the decedent never had any kind of relationship with. So in this particular situation, we had beneficiaries who never knew the individual who passed away, who ended up inheriting the estate. And in this case, the estate was well over $5 million. So this was a very, very kind of fun from our perspective, in the sense that we were handling the probate. We got to make that great phone call to a beneficiary to say, hi, by the way, you're going to get about $1 million. You can imagine that none of them in the beginning believed us and thought we were absolutely scamming them. But it does go to show that even having an estate and plan in place, it's always critical that you keep it up to date, because things will change. He had made some wonderful charitable gifts back in the 1960s, giving some charities of his choosing about $500 a piece. And back then, that was a nice amount of money to leave to a charity. But of course, by the time he died, that it probably ended up being a very small amount of what he otherwise would have wanted to provide to those charities. So really critical that even with an estate plan in place, that you make sure that it's up to date.
Yeah, we had another case a few years ago. Young couple, they created a will. They didn't have any children at that time, so they named the husband's parents as the beneficiaries of the will. Fast forward, I think 10 or 15 years, the couple got divorced. So when you get a divorce, it automatically removes the former spouse from a will by operation of law. But the parents were still named in the will, and he never changed the will. So when he passed, his former in-laws received a substantial inheritance. So and this goes to the point, you always need to look at your will, make sure it's still up to date. The things about wills is that you may change priorities over time. As you have more children, or maybe your desire of who gets what changes, but that's why you have to take a look at it. The probate laws change over time as well, and also your financial position. So these are things in the mix you always need to take a look at to make sure my will accurately reflects my wishes.
Right. Another thing that we oftentimes see in older wills, or unfortunately with people who might use some of the kind of do it themselves kind of programs, is there may not be the required authority in the will. So for instance, we name a personal representative in a will who will be responsible for managing the person's estate after they've passed away. And by law, there is a level of authority given to that personal representative to be able to gather bank accounts and pay bills. But the law does not provide for the authority to sell real estate. So if someone owns a piece of property when they pass away, and their will document doesn't give explicit authority to that person to be able to handle the sale of a real estate or piece of property, we have to go back to a court and we have to get what we call a license to sell. It's a specific authority to let us move forward with the sale of the property. The issue there is that there's time and expense associated with that goes against the estate. So that mere fact that the will didn't have all of the authority that it needs to have in it to allow the personal representative to do their job without this ongoing court involvement for every decision is taken away. We need to make sure that that language is in the will. So critical, again, that wills are updated with time to make sure that they're reflecting your wishes, that you don't end up with some unintended beneficiary getting whatever you have left, and that there's the appropriate authority in that will too, so we can avoid that court involvement. As Phil said, boy, I'll tell you, the courts really, they've been struggling. COVID really did a job. Most of them are only about 3/4 in terms of their normal employee level right now, and we're really seeing it taking its toll. But for anyone who lives in Suffolk County, we laugh a little bit in the office. It's one of the probate courts that we look to avoid, only because they are so overburdened in terms of the amount of work that they're handling and the level of staff that they have. So it's one of the courts that we truly don't want to go to if we can help it.
Yeah,
Right.
some of the things you would look for in a will that's, again, do yourself, it may not include is unsupervised administration of the estate, which means if it's unsupervised, that the PR manages the estate. If it need court supervision, then all decisions need to be reviewed by the court and an administrator. So that hopefully that's language is in the will. Also, not having to post a bond without sureties, meaning you don't have to go out and purchase a corporate bond to ensure the PRs, safely and managing the estate by the terms of the probate court. So some of the other authorities you want to make sure they're in the will. Any wills that are done with us would have that authority. It's not something you need to be concerned about, but time to time we see it, and that's why you have to look at each and every will. And believe me, if it's not there, then it's more time, money, and expense with the probate court, and aggravation too, I may add.
Right, right. So, in talking about these horror stories, we're not trying in any way not to discourage people from having wills. Wills are an important part of an overall estate plan, but they do come with lots of complications, and the complications can be the things we talked about: court involvement, delays in terms of getting the probate proceedings through the courts and being able to get authority to the personal representative. There are abilities, because it's a court proceeding, it opens up oftentimes the estate to people being able to fight about things. And we see sometimes people fighting about things even when common sense tells you there are no grounds for that fight. Oftentimes we find that it's just a way of trying to get something from the estate. Somebody makes a claim against the estate that for some reason they should be a beneficiary, and it will hold up the court proceedings, and it will oftentimes delay the administration of the estate. And we oftentimes find that sometimes it is less expensive to just compromise with that person than to fight out the issue, because as you can imagine, court proceedings are very expensive. So
we've seen situations where a decedent purposely and intentionally cut out one of the children for various reasons, and that child, would purposely contest the will. Obviously they're not getting anything. It's just to hold up the proceedings. So by having assets pass through the will and through the probate court, it delayed everything, and eventually there was a settlement, found just to remove that person from contesting the will. And that's why we're going to talk about trust in a second, but this is one of the reasons, with a will in probate court, again, everything is public, everything's open to challenge. Trust or private. So there's certainly benefits. I think Kathy's going to speak to right now.
Absolutely. So Phil talked about other ways of avoiding probate, putting named beneficiaries on assets, joint owners on assets. Those can come with their own complications. But they are ways of being able to avoid the probate proceeding, because it ensures that that asset will pass outside of the will and outside of any probate. Another way to do it is to utilize a trust. Trusts are documents. Those of you who have worked with us have heard this before, but particularly revocable or revocable trusts are ones that are created during your lifetime that you are the beneficiary of, that you are the trustee of, so you control the trust. And during your lifetime, you can make updates and changes to that trust to reflect whatever's going on with your situation, both privately, your family situation, health situation, and your financial situation. But the benefit of a trust is that as long as you've put assets in it while you're alive, those assets upon your death are owned by the trust. And so they are not controlled by your will. It is the trust that will control them, and the trust will provide us instructions on what to do with those assets. The trust will also name a successor trustee, the person that you want to manage things after you've passed away. And so it avoids the court proceeding. It avoids probate. Now, nothing is foolproof in terms of the ability to fight about it, but trusts make it much more difficult. There is no immediate entree into the court system like there is with a will through the probate proceedings. And trusts are private. They are not documents that are put on file with a court. They are private documents between you, the trustee, and your beneficiaries. And so it really gives a much smoother way to be able to pass on assets. It allows for it to be done so privately and usually more quickly. Now, there's administration that goes with the trust, and it does take some time because things like taxes and everything still need to be dealt with. But they really do help to avoid all of the issues that we've talked about in terms of wills, and the fact that people really can end up arguing about who gets what under a will and whether they were cut out and how long the court takes. All of those kinds of things we avoid with a properly written trust.
Yeah, another way to look at it is that a will only comes into effect when you die. So it's a document you put on your shelf. A trust, as soon as it's funded, by the terms of the trust, manages that asset. So this is particularly important if you ever become incapacitated. The trust could be managing the assets, although you could have a power of attorney or healthcare proxy, but another way to manage assets for the benefit of loved ones.
Sure.
If there's no will involved, and I'm assuming also no trust either, how long do potential beneficiaries have after someone passes to pursue assets such as a house? Would it be less than a year, or would there be no time limit?
I'm not sure I'm understanding the question completely. I think it is, that someone passed away and let's say they owned property somewhere and no one ever did anything to get that property into the heirs or beneficiaries' hands. So certainly, until something has to happen with that property, meaning that it's now going to be sold or something to that effect, nothing necessarily has to be done. I mean, it depends. If there's a mortgage on the property, somebody's got to be paying the mortgage, or the mortgage company is going to go ahead and foreclose on the property. Somebody better be paying the taxes on the property, or the truth is the town is going to begin proceedings to take the property as a tax taking. So, but let's say for some reason, people continue to make sure that the property is being maintained and the electricity stays on and the heat stays on and all the taxes are being paid. Well, oftentimes we'll find that there is an issue with the title on a property when we go to sell it. So suddenly now the decision is to sell this property for some reason, and we look back and we say, wait a second, it's not actually in the name of this person. And Phil, we had dealt with a client who, had inherited property from someone else and never did the proceedings to make sure that that property got titled into their name legally. And now they passed away. Well, this can be a real mess because now we've got multiple layers that we have to go through to do what we call clear that title. We have to be able to show that somebody has legal authority to be able to transfer ownership when we're particularly talking about real estate to a new owner. You would not want to buy a property and find out later that somebody else owned it, that you actually didn't get a clear title, and that there may be other people who have a claim to that property or a mortgage still on that property or something to that effect. So it can be a situation in which nobody does anything, but of course there are other consequences that may come with that, and that a probate proceeding needs to be done in the future. Since 2012, when our probate laws here in Massachusetts changed, used to be that you could initiate a probate proceeding at any point. Now there is a 3-year limit to be able to do what we consider to be a full probate proceeding. If it passes the 3-year period of time, and this is really when we're talking about real estate and the transfer of real estate, after 3 years, we are limited to what we can do with the court, to what is called a late and limited filing. And the purpose of that late and limited filing is very narrow. It is just to get someone appointed as the personal representative to manage the estate for the one goal of transferring the ownership of that asset, the real estate in this case, to whoever the intended beneficiaries are. So no longer can that personal representative sell the property. They must transfer it to whoever the beneficiaries are, and they're done. So, but if we did it before the 3-year mark, the personal representative would be able to sell the property, potentially use some of those funds to pay off liabilities that might be there, taxes, bills, that kind of thing of the estate. They have more of a scope of authority of what they can do. So ideally, we always want to get an estate probated in 3 years if we can. Otherwise, we can be limited in terms of what the personal representative's job and authority is with respect to the assets. I hope that answered that question.
Yeah, let me give you an example that maybe helped drive the point home. I recently had a case where parents passed away 30 years ago, and they had 2 daughters. They never had a will. So by intestate, which means without a will, the ownership resided in the 2 daughters. They never took any actions, never probated either of the parents' estate. One of the daughters got married and moved into the home. They had lived in the home for 25 plus years. And then one of the daughters, who were the original daughters, passed away. And so now the husband was trying to sell the property, and surprise, surprise, his sister-in-law, who he does not get along with, owns half the house. So it caused so many problems, not only with the probate court, but it absolutely killed the proposed sale. And it was delayed months, and agreement had to be worked out. It was just unfortunately a difficult situation for all involved.
The other thing that sometimes comes up too is we may find a surprising bill, a lien against the property. So for instance, someone owns a piece of property, they pass away, but before they died, they received benefits from the Commonwealth under something like a mass health program. And the Commonwealth put a lien against the property. Well, lo and behold, 15 years later, now we're trying to get that property sold. And one thing that may show up is, oh, by the way, this lien needs to be satisfied before that property can be sold. And the state doesn't just sit back and say, we're going to put a lien on, but nothing else. They've been tolling an interest rate against that lien over all these years. And it could be quite a substantial bill that is owed. So delaying probate because you think it's a way of maybe not having to deal with something like a mass health lien or some other liability, or just because you just don't want to have to deal with it, can really have unbelievable unintended consequences for the future. And
Yeah,
so
you
it's
want to
really
open up a
important.
probate and then within the statutory limits, close it. You want to, end any opportunity for anyone to make claims against the estate. You want to terminate the estate, acquire, manage all the assets, distribute to the named beneficiaries, and then through court approval, close the estate. By having it open, then there's liability. We don't want the personal representative still have that hanging out there and be subject to that. So always good to, within the statutory time, 1 year, open, close, and complete the estate. where
So
possible.
Phil, you brought up an interesting point too. Remember that there are many categories of people who can open up an estate. So let's say that you are a personal representative named under a will, and there's an estate that needs to be administered and you just don't do it. Well, a beneficiary can start the proceedings and they could say to the court, look, you didn't do your job, so now we're asking for someone else to do it. And the court may allow that to happen. Or a creditor could come forward and say, I am a creditor of the estate and I want to start the proceedings to make it so that I get paid. And if those things happen, you as the personal representative, if that's your role here, may lose your ability to act in that capacity. And so if you've been asked to be the personal representative under someone's estate, it really is critical that you act timely to make sure that things are taken care of before something happens that you lose that ability. I also want to jump for a moment, if I could, to talk about some other proceedings that happen under this category of probate. We've talked a lot about wills and we've talked about when someone passes away, some of the horror stories, but we also see horror stories involved when someone is still alive, but if we have to seek guardianship or conservatorship. And this is when someone has failed to do planning, usually ahead of time, and now are in a position in which they no longer have the competency to do the planning. So they didn't put together a power of attorney or a healthcare proxy, or maybe they did put one of those documents together, but they didn't have enough authority in them to let their named representative do what needed to be done. So under the guise of probate and in the courts, they also handle guardianship and conservatorship proceedings. Guardian being when someone is named to manage decisions about the person, and oftentimes to handle things like healthcare decisions, and a conservator when someone is needed to manage the financial life of an individual. And when you start getting the courts involved, again, you're talking time, you're talking expense, you're talking about lack of privacy because these proceedings are public, and you're talking about needing the courts to continually have oversight and to have to go back to the courts sometimes to get more authority to do the things that you need to do. So avoiding these situations, not only with the things that we talked about in terms of avoiding probate with a will after someone has died and utilizing trusts and named beneficiaries, also need to think very carefully about taking care of the documents that have to be put in place should you lose your competency or capacity. It allows you to control who's going to step into your shoes, and it allows you to keep the courts out of it whenever possible.
So I have a question here.
Sure.
Someone discovered that after their parents' estate was closed, that there was an investment remaining. It ended up on the Mass unclaimed property list, and it would be too expensive to reopen the estate. Is there another way to go?
So it depends. Sometimes, depending on who the creditor is, if it's a bank, et cetera, and the value of the asset, there are some other ways. The state has a simple estate affidavit, and it's again for certain asset values below a limit. And I apologize, I don't know, but that is on the website for the state treasurer's office. That may be a way to claim it. Now, another thing to remember that even though an estate may be closed, and so as Phil said, you want to go through all the legal proceedings to administer the estate timely and then get it closed down, so you're now away from having responsibility if you're the personal representative. Even if that has happened, even if you've gone through a closing process with the state, you still are able, if you're alive and capable of it, if you were the named personal representative, you still are able, under certain circumstances, to be able to get a copy of your appointment and use that appointment to be able to gain the asset that is with the state. If not, then you do have to go to the court and you do have to do something either to get a successor personal representative appointed. And there are court proceedings and costs associated with that. And oftentimes you have to weigh, is it worth it? Is it worth the time and energy for whatever this asset may be? So I think that's it. There's a lot of information we shared. I hope you found it entertaining talking about some of the things that have happened with people's wills, and some of the horror stories that we have seen.
Don't let you become one of our horror stories. So always keep your plan up to date. Work with your estate planning attorney and make sure it reflects your wishes.